Hi everybody, my name is Bazikyan from Bazikyan Law Group. I am a wills and trusts attorney here in Los Angeles, and in this month's video, I wanted to discuss the lingering legal rights that your ex-spouse may have in case you pass away. So what do I mean by that exactly? For all of you out there that are divorced, officially divorced, you may think that once your divorce decree comes down, you are free to move on with your life. However, if you have children that are minors, there may be some lingering rights that your ex has that you're not aware of. So I wanted to go through an example to highlight what it may look like to help illustrate what I'm talking about. I find that examples are the best way of teaching. So let's pretend that Cindy and John have two children. One of them's 9 years old, one of them is 12 years old. And Cindy and John used to be married, but they got a divorce. They are living separate lives now. Their divorce is final. And Cindy moves on with her life. She buys a new property. She has investment accounts. She has life insurance. And she moves on with life following her marriage with John. At some point in this hypothetical, let's say Cindy passes away. When Cindy passes away, her estate, everything that she's amassed, so that's the house, her investment accounts, life insurance, will go to her heirs. So let's say Sydney did not do any pre-planning, she didn't have a trust, she didn't have a will. The court, state laws will dictate that the estate will go through the probate process, and her heirs will be the rightful inheritors of her estate. So who are the heirs at law in her case? It would be her two children. Okay, so it's great news. You know, ex-husband doesn't get anything. The kids get it, which is great. However, they're minors. They're under the age of 18 in California, which means that when they inherit this estate, the court will require a guardianship for their assets to be in place. So the court will name a guardian of the estate, which is the person, think of it like a custodian, the person that's going to be in charge of these assets, that's going to safeguard them until the child is 18. Most of the time in scenarios like this, if the other parent of the child is living, that parent is going to be pretty high up there in ranks to be named as the guardian. So if John applies to the court and says, hey, I'm the dad, I have my child's best interest in mind, I am already their guardian because my ex, their other parent, has passed away, let me also be the guardian of their estate, the court is probably going to lean towards that absent any objections by other people. So we're actually going to have a scenario if we play it out to the end. So no planning, we play it out to the end, we see the bad result where Cindy has passed away, she didn't do any planning, and all of a sudden her ex-husband is the one that's controlling all of these assets for her children. And at the age of 18, he's required to turn it over. Very bad result. Even if she didn't mind that John was the one that was in charge as the guardian of the estate, we still have a scenario where these kids are coming into a large inheritance at a very young age of 18. And we all know what 18-year-olds will do with a chunk of money, right? We're going to assume that they're going to blow through it very quickly. So these are kind of unintended bad results with no planning that we see in a scenario where we have a divorced parent of minor children. If we play it out to the end with the reverse scenario where we imagine that Cindy actually went in and had a plan drafted up by an attorney. She had a trust in place. All the assets were funded into the trust, and the trust actually provided that the children receive everything in her estate. However, she would put up some discretionary measures or some conditional distributions to help the kids get their inheritance in smaller portions, maybe at older ages, so she can have more control as far as how her children are inheriting the assets. And she can actually control who is the person that's in charge of their estate. So with utilizing an estate plan and a trust, Cindy can actually take that power away from the California courts, so away from a judge, and actually name a trustee and have that trustee have discretion to distribute the assets to the children. And the trustee will be able to be the one that manages the property and the investments and whatnot, and safeguard it and grow it for the kids. So it'll allow the trustee to have a little bit more flexibility in how they are managing these assets without the oversight of the California court system, without a judge supervising every little move. So that's the positive outcome when we see a person has actually gone ahead, sat down with an attorney ahead of time, and discussed all of these matters and pre-planned what happens in case of their death. So if you're a divorced parent and you have children that are under the age of 18, there may be these unwanted consequences of your ex having control over the assets. So if that's not something that you like hearing, then definitely sit down with our office, contact me. We have free consultations. Come in, sit down, and we will put together a plan of action, and we'll put together a comprehensive estate plan that'll address all of these concerns and take care of all these problems so that your ex is not involved in the picture. So feel free to contact our office.